one thing.
Yeah, if you spot him in the waiting room first, then you can also let him in, but I'm checking as well.
I will check it, sorry.
If he's under a different name, then maybe he has to tell us, but I hope.
The link has been sent, right, to him? Yeah.
Yeah.
I think there's a lot of people at Martin for a webinar. No, we were at 62, so 63.
But where is Philip?
Wait, I will send him.
There he is. Now I found him. Maybe he just entered. There he is.
Hey there, sorry for the slight delay.
No worries. I got a bit confused. Hello, Philip. Nice to see you again. I got a bit confused, but I sent the Teams the Zoom link right to everyone. I was a bit confused, but yeah.
Okay, maybe I missed it. I'm sorry. I'm just getting too
No
many.
worries. Most important thing is that you are there. So welcome everyone, and I think we can start in about some minutes. Is everything from the first of all, thank you for being here. I think it's great to have such a lineup of yeah, really the top-notch experts nowadays on these topics. So it's really a pleasure. I just have one question to all of you. Are there still remaining questions on the program, or as you see, the slides will follow really the agenda. So, and I will moderate. I will also give a signal when the timing is over. So, are there any specific questions on your side still? All right. I already asked to the those that were here a bit sooner if it's okay that I when I present you, of course, I'll say Professor Philipp Hacker, but then during the discussion, would it be okay, Philip, as well, that I say Philip, or do you prefer Professor Hacker? I know I don't know the formalities you like, so I'm happy to follow whatever you want.
No, you cannot call me Philip, of course. That would be absolutely outrageous. So I insist on full titles all the time. No, please don't call me. Don't even use the professor thing. It's all good.
Okay, but since you insist on the full titles, you'll be the only one that I will address with full titles. So no, it's okay. I'll just do it informally. So yeah, no, thank you very much. And yeah, no, I think we can let everyone in, Alexandra.
All right.
All right. Good afternoon, everyone. Good morning, everyone. I don't know wherever you are in this world, but very much welcome to our seminar, our webinar on AI liability. Where should the European Union go? And as you know, a lot has been happening at the EU level recently on AI liability, and this is why we thought it would be an excellent idea to gather some the leading voices on this topic nowadays. And I see that a lot of people already joined this webinar, and it is of course fantastic to see so many enthusiast people for artificial intelligence and especially questions of liability. Now, the context, of course, ladies and gentlemen, is that a lot is happening on AI and the liability it causes. We all know these incidents with autonomous vehicles, highly debated, but also robotic used in surgery, also perhaps AI systems that discriminate and lead to damage. 2 years ago, there was also a report in Belgium that unfortunately unfortunately, a man committed suicide after having interactions with a chatbot. It led to a lot of discussions and debate. And so the questions of liability are really already there for a long time, but have since this year actually gained a lot of interest in because of a lot of recent evolutions. Now, if you look at the context of the webinar, and I will briefly afterwards discuss, of course, all the speakers and also the platforms that we use and the organizations behind this webinar. But if you look at the context of liability, of course, we had many discussions already for a very long time. The application of the Product Liability Directive to AI systems, well, has been debated already for a decade. Qualification of software as a product, and you know the traditional paradigms, the traditional unclarities when it comes to these topics. A lot of attention has been given as well to procedural elements, namely the burden of proof, and especially the position of the victim that is considered to be a weaker party, not having access to the information, not being able to build a claim in court, so to say. Voices have been raised to go towards a strict liability for operators. I have referred to different studies that have been done in the past, but also on insurance coverages, and even the question whether legal personality should be considered for AI systems. And this has been proposed by the European Parliament, has been rejected afterwards by almost everyone else. But you see, a lot has been already going on since quite some years already. Now, recently, and especially since 2025, we see some very important triggers. Of course, we have the AI Act that is being adopted in August after a long process. We also have the revision of the Product Liability Directive, dated back from to the 80s. Now we see that it was no longer fit for purpose, no longer fit for this digital context. And this is why these important amendments have been made. Qualification of software is now a product under certain situations, the broadening of the producers towards economic operators, but also some kind of defenses that were adopted now to the digital context, but also the circular economy. So these important triggers have been there since a couple of months. In February 2025, you may notice the European Commission revoked the AI Liability Directive, the proposal, because of the impossibility to reach an agreement between the member states, between the involved actors. Now, this withdrawal has had a major impact, and I think we have had a lot of discussions following that withdrawal, because a lot of people say, well, this is a missed opportunity. Some others say, well, it makes sense to get it revoked because it does not fit well with national liability regimes. But the most important thing is that a lot is happening again on AI liability, in combination with the AI Act, in combination with the revision of the Product Liability, in combination with the withdrawal of the AI Liability Directive proposal. Of course, in combination with sectorial legislations that are out there, medical device regulation, the GDPR. So we do face indeed a lot of unclarities. And the most important question is, what way should the European Union go? What way should we go with the European Union in light of recent evolutions, but also what is the role of member states? What is still left to member states? Because as you know, tort liability is still to a large extent national law. Does it make sense? Should we not harmonize this? Which aspects do we harmonize this? So this is why we decided to host this webinar on AI liability, to cover all of these different modalities, and especially to discuss some solutions and the way forward. After this, at the end of this session, we will also provide some references that you can include, and actually we will see that it's based on some research briefs that have been going on at CITIB. Now, more importantly, we have this webinar, where should the European Union go or not go? And I'm very happy to see so many people attending it. Now, first, a very short overview of the organizations behind this webinar. And of course, we only facilitate. The real stars of today are the speakers, excluding myself. But we have, first of all, the Robotics and Legal AI Society, RAILS, which is the platform. And we have Professor Martin Ebers here as the president. He will do the closing remarks. But we do a lot of things. We have webinars, we have events that we do. We are involved in projects. We were even, RAILS was even the first party that took the We Robot got conference to Berlin, to the European Union. So this is great news. I provided hyperlinks also in the different organizations involved. So if you want to have more information, you can directly go towards that. KU Leuven Center for IT and IP Law, CITIP, is where I'm working at, is also one of the organizations that is involved in this webinar. And then also the Knowledge Center on Data and Society is it's a Flemish organization that does a lot of cool things. For example, on policy prototyping, transparency. They translate academic research also to the different stakeholders, companies and citizens, but also civil society. So this is a brief overview of the context. So maybe the relaunch of a lot of discussions following the the withdrawal of the Commission's AI Liability Directive proposal, but also the many unclarities that remain. Now, more importantly, ladies and gentlemen, I'm just the facilitator, I'm the moderator. I will not giving my view, but we have experts that will share their view the coming 1 hour and a half, 2 hours. First of all, we have Professor Philipp Hacker. He's Professor of Law and Ethics of the Digital Society at the European University in Viadrina in Frankfurt-Oder. I think we all know Philip from policy reports, very recently even. He's, I think, one of the leading forces when it comes to the regulation of AI and liability in the European Union, and has been working on that topic already for a very long time. So I think it's great to have him with us to share his views. I think they're always interesting, and it will be thought-provoking and leading hopefully to some discussion. We also have Shu Li. He's assistant professor in law and AI at the Erasmus School of Law. And interesting with his profile is that he actually uses a lot of law and economics perspectives in his research. I think you can find his papers as well online. And he really sometimes departs from the law and economics view on the AI liability questions. Dr. Beatrice Schütte, she's a postdoctoral researcher at the University of Lapland in Helsinki, and she's been working on liability already for a very long time. And it was a pleasure meeting her today because, of course, we read each other's work, but finally we were able to connect a bit as well, and hopefully she will also give her insights on AI liability. Miriam Buiten, professor of law and economics at the University of St. Gallen. Shu Li, she's departing from this law and economics perspective and did a lot of work on the product liability directive. I think she did several reports from SEA, for example, where she shed her light on the different possibilities, challenges, especially in the context of the product liability directive. And as I mentioned, there's a real overlap coordination between whatever we need to do in the future. I also see that we have Mindy Duffourc. She's assistant professor of private law at Maastricht University, and she's really an expert in liability and AI in the context of medical law. As I mentioned already, the AI Act, the revised product liability, of course, they interact with sectorial legislation. For example, the medical device regulation and a lot of other health-related legislation. So I'm also very happy that we will have that view as well on the impact of the where should the EU go, take into account as well the importance of medical law as an important sectorial field. Finally, we have Professor Martin Ebers. He's professor at the Tartu University, and as I mentioned, he's also the president of Rails. He's actually the leading scholar. I think he published so many books, so many scholarships, so many articles. He's almost involved in a lot of these initiatives. So it's also great to have him on board. As I mentioned, I'm the least important one today. I'm just moderating and giving the stage to the experts. I'm Jan de Bruyne. I work as professor IT law at the KU Leuven, and I'm also the head of the Center for IT and IP Law. Now, ladies and gentlemen, now that we know the context, now that we know the speakers, we can go more into detail. And what is planned today? Well, we have a quite interesting packed agenda, and I will first start with a quick round. We will start with a quick round where I will ask the different speakers to give their view on the question, is it now a good thing that the AI Liability Directive proposal has been revoked or not? Very shortly, 1 to 2 minutes, they will already set the scene so that we really know, okay, what are the different views, what are the different perceptions, and this could then lead perhaps to some discussions already. After that, each of them will have a 10-minute pitch where they will give their view on AI liability. What do they see as priorities? What do they see as the way forward? What are some potential challenges? What are some potential hurdles? What should we do? What should the EU do? What should member states do? So I really hope as well that not everyone will agree to the same things. I hope we'll have some diversity of views. I think that would be fantastic for the debate. Afterwards, of course, we will have some key takeaways. We will have some Q&A and discussion among speakers. And afterwards, I will end with the key takeaways. So they get 1 minute to give their major key takeaway. I think it's always interesting for the audience. And then finally, Professor Ebers will close the session with some final remarks. Before we start, ladies and gentlemen, let me first thank again all the speakers for being here, and some I would not say rules, but some guidance and some things that we would and I would especially appreciate. Please mute yourself. I think we now are really very well aware of webinars, so please mute yourself because it's sometimes annoying as a speaker if you hear background from somewhere, so mute yourself. That does, of course, not say that you cannot be involved. We have the chat, so please, if you have questions, if you disagree, agree, if you want to share something, please do so in the chat. It's open, and I would be very happy to see a lot of views, a lot of perspectives, and I'm hoping and I'm confident that the speakers will also react on whatever has been posted on the chat. As I mentioned, we have distinguished speakers, really key experts that are gathered here. So please, if you have questions, feel free to share them and feel free to ask your thoughts. That being said, we have the context, we have the program. Now it really starts. And my first quick round is this withdrawal of the AI liability proposal an opportunity, or is it a realistic thing that should have happened? I refer to the thing from Reactive that I read some days ago, some weeks ago, that the Commission revoked this proposal in light of the recent events in the United States. But of course, my question is to the speakers. In 1 minute, what do you think? Is it a good thing or is it a bad thing? Is it a missed opportunity or is it realistic? And I will first give the floor to, if that's okay, to Philip. So Philip, please, what do you think about this statement? 1 minute afterwards, you get a pitch of 10 minutes. So what do you think?
Well, thank you. Very briefly, so first of all, I don't think it has much to do with Van's speech directly, because the Commission work program had been under consideration and in development for a long time. And we see at the Commission level that now there is a push for simplification and for easing the burden, particularly on SMEs. And it's rather in this context, I think, that the idea was born to scrap the ALD format. However, of course, the recent change in administration in the US made that even more imperative, apparently, to policymakers in the EU. I think it is indeed a missed opportunity. I think other people will also comment on that. I just want to highlight maybe 2 or 3 things. First, was it good for innovation? I don't think so, because in the end, now we have a fragmented landscape with 27 different rules, both procedurally and substantively. Second, it was a particularly bad moment for SMEs because, as you probably know, I was working also with the European Parliament on that file and advising the rapporteur. And so one of the things we had very much on the table was protections for SMEs against buyout clauses, basically big companies telling them, you can use our model, but if you do that, you cannot turn around and bring liability to us, have recourse from us. And the third thing is, it's also a pity because within the context of competitiveness, that could have been completed the picture of AI liability in Europe, and then we could have started having a real conversation on whether we want precautionary or, let's say, direct AI regulation like the AI Act, or replace some elements of the AI Act with a more liability-focused regime, which I think would have been a very interesting conversation to have. But now we don't really have parts in place for that. Thanks so much. Much more would be to say, and I'm looking forward to the comments of my fellow speakers.
Philip, and I already hear some interesting things: regulation, innovation, potential for SMEs. I'm quite sure you'll come back to that in your pitch and afterwards during the Q&A. Thank you. Beatrice, what do you think? What is your key takeaway on this first quick statement? Is it a missed opportunity or a realistic a realistic thing that was supposed to happen, so to say?
Thank you very much, Jan. I would say it's a bit of both. On the one hand, I agree to a large extent with Philip. It is a missed opportunity in the sense that we will continue having legal fragmentation across across the EU when it comes to liability. We know that the practices of courts when it comes to liability proceeding, it differs across member states. So it can be a bit of a lottery depending on the member state you're in, the private law that is applicable. Are you able to obtain compensation or not? On the other hand, to a certain extent, well, was it something that had to happen? It wasn't a big surprise because the negotiations have been stalling for quite long, and we know that many member states are very reluctant when it comes to harmonizing private law. So yeah, to sum up, on the one hand, it won't put us in a better position because we keep having legal insecurity, legal uncertainty when it comes to liability. On the other hand, probably the way the directive was formulated was not the way to go. So let's see what's going to happen in the near future. Thank you.
Okay, and also interesting to see the law answer. Yes, no, yes, but I like it already, and it sets the scene for the discussion. So thank you, Beatrice, for your view as well. Shu, what do you think? Perhaps a law and economics view. Also, what do you think about this first quick round and this first statement?
Yeah, thanks, Jan, and thanks, Philip and Beatrice for the comments. I would slightly prefer that it is a realistic decision. I mean, it is kind of, as Beatrice said, a missed opportunity, but I would say there are two things are missing according to the current form of this AI liability directive. First one is I really did not see the real added value of this proposal, and according to its, the current form of this proposal as it is. And secondly, I think there is a problem, and which cannot convince me, for example, the consistency between this AI liability proposal as well as other legislation. So in that two cases, I would slightly prefer that this is a realistic decision. Maybe later we will prepare a better version compared to this one. But at the moment, I would say it might be a realistic decision.
Okay, thank you, and already interesting to have a diversity of views. So I think it will, I think it will lead to some interesting discussions. I also hear the coordination problem, lack of consistency as two major downsides. Eventually, hopefully, leading to something better. This is something that I note as well, and it can be a nice, already a key takeaway. We're not there yet, but it could be a nice key takeaway. Thank you, Miriam. What do you think about this first statement?
Thank you, Jan. I wouldn't call it a missed opportunity because, better good regulation than sort of too hastily accepting something that is there. In my view, the question of what we concretely want to solve was stepped over too quickly with this directive. And in the process of also speaking with people from the Commission, of course, there were ideas about these are the problems for liability, but I think we need to dig deeper here on what exactly we want to achieve with this. So, don't get me wrong, I do think that AI poses challenges for liability, but I don't think it fully addressed the type of issues that we may have. So 2 points on this. The first is, what can an EU approach really solve? So I'm somewhat skeptical that innovation is going to, or legal fragmentation can just be solved by a framework for AI liability. We have to be realistic. The national legal regimes will always remain relevant. So I'll get back to that later. And the second point is, we have different types of systems. Some might be strict liability nationally, some might be fault liability. We have to really get to the problem. What is it about AI that is creating a problem for liability? What concrete use cases could we think of where right now a national court could not deal with the problem? So before we devise a new solution, which we may want to do or maybe not, personally, I think we should be careful, but if we do that, we need to think really about what it's supposed to achieve and then maybe devise a better solution as Shu has suggested.
Thank you. And the devising a better solution, at the same time, the more substantive you go into national law, the more problematic it can become. And so you already have these dilemmas that are so interesting, and we all work on tort liability, private law, which is so interesting to look at. And I also have the impression that AI actually relaunches some discussions that were already there in the past. The principles of European tort law, contract law, these ideas of coming to a codification, well, they failed, but perhaps the AI debates can lead to a new attempt on that. Miriam, thank you very much for your view. And then finally, Mindy, what do you think? Perhaps a more medical link with the MDR, I would assume. But please take the mic and be all listening to you.
Yeah, thank you, Jan. So I agree largely with what's already been said, and especially what Miriam just pointed out about trying to figure out the exact problem we're trying to solve. I think that was a huge weakness. So I will adopt, I think, Beatrice's position that I would say it's a little bit of both. If we look back at the original product liability directive, that took nearly a decade to kind of reach a consensus, which to me signals a couple of things, like tort liability and finding some way to provide uniformity there is a difficult process, and it requires quite a lot of negotiation. So yeah, I mean, procedurally, whether withdrawal and sort of kind of starting from the beginning is the right approach, or continuing negotiations. So I think maybe there is some opportunity, but I wholeheartedly agree that this was not the directive to solve problems for AI liability, because I think we haven't quite identified exactly what those problems are. And for most of my professional life, I was a litigator in court. And I think one of the big things about liability as opposed to regulation is that it moves out of transactional space into courtrooms. It becomes very fact specific. It becomes very dependent on procedural rules and local rules and regional rules and national rules at all levels. And I think we really need to understand what the problem is at that level, right? So it's not just like some set of laws or legal rules that we can make perfect. We need to understand what the problem is for AI specifically, for liability or fault-based liability, if that's what we're tackling specifically, because I think it's not just complexity. I mean, so medical malpractice cases are extremely complex. It's very difficult for patients to get information. Sometimes they're unconscious when things go wrong, right? So it's not just complexity or information, in inequalities. It's more than that, and we need to figure out what our current law doesn't quite solve, right? Because I think some of it can already be dealt with because we see it in other contexts, and this kind of gut reaction to like, oh, it's so hard to understand, and that's what we need to solve was not quite right.
Thank you. Sorry, I'm not used to work with Zoom, so sometimes I fail to find the right button immediately. But thank you as well, Mindy, for your view. And I think already you touched yet upon another thing: the availabilities, the gaps, remedying gaps, and the coordination that is needed. Now, we have now set the scene, and we know what every one of the speakers is thinking, and the core message is out there. And of course, as I mentioned already in the start, this event is also taking place within the Belgian AI Week. So we are also live streaming on YouTube. So I hope there will be other people as well joining. I hope Belgian policymakers will listen very carefully, because I think a lot of the problems are among others in Belgium. So please, we now have set the scene. The different views on AI liability, already different elements were touched. Based on that, I think we can now move towards a more pitch. The different speakers will get 10 minutes to pitch their ideas, their research, their concerns. And based on what has just been said, I may already feel that there are some differences. As I mentioned, please use the chat, the participants, the audience, feel free to drop any views, any questions. If you disagree, agree. It would be really nice to have some interactions on the chat as well. And I will be moderating it. Speakers could contribute. Now, the first speaker that has got 10 minutes, and I will give a signal when the 10 minutes are over to make sure that we end on time, is Shu Li. Shu, please, 10 minutes for you. How you see AI liability? It can be anything. What is your 10 minutes pitch on this topic?
Thanks, Young. I will stop in 10 minutes. Actually, first of all, I agree that there are some highlights in the AI Liability Directive proposal. For example, it opens the door for collective action to remedy the damage caused by AI system. And also, I agree with Professor Philipp Hacker just mentioned it offers something, let's say, approach for the small and medium-sized enterprises. But here I would not discuss in detail, let's say, the good and bads of this current form of AI liability directive proposal, because I think this have already been, let's say, widely touched upon by the literature, which, let's say, many from these panelists, as well as I saw many from the audience, they also wrote a lot for that. So in this very short presentation, I try to cover three issues. The first one is I want to, from my perspective, I want to explain a little bit about what's the real added value of this AI Liability Directive proposal. And secondly, I'll discuss a little bit about the future of AI liability. And lastly, I will conclude by, let's say, asking two open questions. The first issue that I would like to comment is the real, let's say, added value of this AILD. So if we read this AILD, we find there are two objectives which are very important. The first one is to reduce the burden of proof suffered by victims. And second one is, let's say, to reduce the level of decentralization or fragmentation. So in that case, AILD adopted a minimum harmonized approach and only focus on procedural rules. I think the good thing by doing so is that it maintained, let's say, a balance. So first of all, it provided necessary protection for consumers, victims, and it also gives member states, let's say, a space to explore suitable approaches that they can explore. But meanwhile, I would say, in other words, we can also rephrase it as, let's say, it set up a scene that different member states, they can compete with each other to explore the best approach that suit their, let's say, situation the best. So which I would say, but you can disagree, can also be achieved without this AI liability directive, because anyway, there might be a race to the top. So that would be one argument. And in that case, that is why I really say mention as I wonder what's the real added value of this AI liability directive, and how legislators, let's say, can with member states to adapt their national law if the added value is not clear, while it, let's say, its potential cost for transplant into the national law is relatively high, and maybe there's some complexity to implement. The second issue I would like to mention is about this, let's say, the future of AI liability. I think very clear. One is the relationship between AI, let's say, liability and product liability. And second one is the relationship between AI liability and AI regulation. So with regard to the relationship with AI liability and product liability, I think this is starting point. If it's still product liability directive is still the starting point. And from my understanding, the beautiful thing of product liability is that it uses defectiveness, let's say, as a factor to when we are considering the liability, rather than the risk or type of product. I think this is very important, and defectiveness is actually, let's say, try to strike a balance between innovation as well as consumer expectation. And if we read this new product liability directive, we find that AI system or software are defined as a product. And therefore, a large part of AI liability is still based on product liability, where defectiveness still plays a role. And I think this logic still, I would say, makes a lot of sense. So if we agree or disagree, under this background, we are talking about future. When we are talking about the future of AI liability, we are talking about, let's say, AI-related harm that cannot be addressed by product liability. So what are the typical cases there? I would say one typical case would be the harm that is not caused by the defectiveness of product. And secondly, I would say it will be the harm that is not compensable under the product liability. So then the key issue is how to allocate the liability among various operators, such as AI providers or deployers. And the popular strategy so far, if we read literature and some, let's say, parliamentary resolution, is we try to link this issue with the risk level of AI application, which means that, let's say, higher risk of AI application are subject to strict liability, while others are subject to fault-based rules. And one of the advantages of this strategy is making sure that it is naturally linked to the AI Act, AI regulation. But in my opinion, there's this approach or this linkage has some problem. So risk-based approach is as I would say, is a good one. We are distinguishing the market entrance of different AI applications. But I would say when we are considering the liability for AI, there are definitely more factors to be considered. So risk is only one factor when distinguishing liability rules. So in tort liability, for example, our primary objective is to make sure that all involved parties are properly incentivized, so the accident cost could be reduced. In order to achieve that effect, let's say factors, for example, in a bilateral accident, for example, which party can reduce the accident at the lowest cost, which party have a better capacity to shift the risk, which should also be considered. And in the context of AI, we definitely need to consider more factors, for example, the level of autonomy of AI, as well as the interaction. So all these factors cannot be easily generalized, I would say, in a one-size-fits-all approach. And therefore, my argument is we really should think about a sector-specific basis. So, for example, this is not new. I mean, let's say in the area of autonomous vehicles, we already distinguish different levels of autonomous vehicles, and then we develop, let's say, different liability pattern for that. And I think this approach might be, let's say, also considered in other domains. And therefore, let's say, regarding the future of AI liability, my two key takeaways are: first, AI liability only as an extra break based on product liability. So we should not discussing AI liability without considering the current landscape of product liability. And secondly, we must break, let's say, the logic that a high-risk AI system, which let's say in the AI Act, will lead to strict liability. And there are more factors should be considered when determining liability rules, and this must be carried out on a sector-specific basis. And my last issue that the last issue that I would like to address is, let's say, what we can do at the moment when this AI liability directive is withdrawn. And I think there are two open questions. The first open question is, I also ask in other occasions, can we really achieve a harmonized liability specifically for AI without establishing harmonized European tort law? I don't think, I mean, I have the capability to answer this question because it's too complex. But what I want to say is that our founding fathers of European tort law have already achieved, let's say, a bundle of principles and guidelines to harmonize, not to harmonize, let's say, to understand the common ground of the European tort law. So maybe work that we should do in the following months or years is to work on or to redefine the common ground of the new guidelines and principles in the digital age. Secondly, and my last point is, we should focus on more about the harm perspective of AI. Let's say we already have discussed a lot on the risk of AI, but our knowledge is really relatively, let's say, fewer when it comes to what is the harmful consequence of AI system. And when I read Professor Philipp Hacker's EPRS study, I really agree that there are a lot of harmful consequences cannot be easily addressed by the product liability. For example, discrimination, the harm to personality rights, and pure economic losses. But I would like to further point out that such harmful consequences may not well be addressed by tort liability at all. So in that case, I would say before we can reach agreement on what AI liability directive should look like, maybe in the next several years, we should also consider how to develop proper schemes which focus on the compensation itself. So this include not limited to insurance, let's say, or no fault compensation scheme, as well as others. So now I would like to finish, and this is my last word. So thank you, Yang. I think This is all.
Thank you. Already a lot of interesting stuff. And as we are running actually 3 minutes ahead, I will just ask Shu Li to ask you, already answer one question by Nina. She's dropped a question in the chat. Very shortly, Shu Li. So 1 minute, would you differentiate the AI liability versus generative AI liability? So I think they refer to, if she refers to the generative AI, normal AI. Would you make a difference there or not?
This is a good question, but I don't think at this stage, generative AI liability should be something different from AI liability. I would say this is something when we are designing AI liability, something there. But I would say also this is about AI models, which are, for example, which are not easily be captured by the AI product liability directive. So this is something that we should also distinguish when we are considering whether we are discussing liability for AI. Are we talking about? That's why I'm focusing on the harm perspective, because then we do not need to consider whether it's product, whether it's services, or whether it's AI models. So that is what let's say, very brief answer to this question.
Yeah, I understand. And also like the harm, starting from the harm would also perhaps increase like the technological neutrality of legislation. If I focus on this harm, I think it makes sense. And indeed, let's go for an harmonized tort law. If AI doesn't work, let's go for that. But I think that's even more difficult. But I note also, because I also claimed for that as well, the revival of the soft law principles. I think it's a starting point to indeed find common grounds. Nina also has another question, but I think we can keep that for a later moment because it's all speakers and a very interesting question. Thank you, Shu Li. Beatrice, the floor is yours for your 10 minutes pitch. And also, if you already want to disagree with something Shu said or you want to react or something, please feel free to do anything. People online, continue dropping your questions in the chat. Beatrice, the floor is all yours.
Thank you very much, Jan, and also thank you very much, Shu, for your comments. I will, as you could already see in my very short first pitch, I will probably stick to my line of it depends. I'm not going to say we should do this, we should not do that. What should be definitely done perhaps in the near future, especially from the side of the legislator, if they want to continue exploring whether or not to regulate liability for AI or not, we should definitely explore different options that we had. And I think one of the main stumbling blocks will continue to be the member states' reluctance when it comes to harmonizing private law matters. As Mindy earlier correctly pointed out, even harmonizing just product liability, which is one aspect, it took very long to reach an agreement on the first directive. It was faster to update the product liability directive than to draft it in the first place. One point that caught my attention, particularly now regarding the withdrawal of the AILD, if you look at it in connection with the revised product liability directive, is that the two, what I see as the two core provisions of the AILD are those on the disclosure of evidence and the presumption of causation. And these provisions are not completely identical, but they are not so different from the provisions on disclosure of evidence and presumption in the PLD. So it makes me wonder what made member states accept such provisions in the PLD, what made it reject them in the AILD. Is it because they, especially the disclosure of evidence, is not something that was very well known in civil law countries, or was it just the general reluctance in terms of harmonizing private law, and one instrument was already there and the other one was new? So what could be done? Shu referred to finding common ground. So one option could be to explore concepts that we already have in member state laws that could possibly help us solving certain questions that we might want to address. If I look again at this approach, we want to make it easier for injured parties to obtain compensation when they have been harmed by artificial intelligence. Would it make sense to possibly explore something along the lines of vicarious liability? Should we explore a concept that is based on the person who uses AI should also be liable if something goes wrong? Because a person who is using AI, if we call it the operator or the deployer or whatever term we decide to use, that would have the advantage that the person who is using the AI system will often be the one who is most easily identifiable for an injured party. Then I'm not going too much into detail because Shu already mentioned there is an option to have just something based on an insurance scheme, so that people could basically direct their claims towards an insurance. We could also probably try and explore other national concepts. So, for instance, I did my PhD in Denmark, and Denmark has something in their tort law what they call like non-law-based strict liability. It's something that is based often a bit on policy considerations. So if someone decides to engage in a particularly risky activity, then the courts may hold that person liable even if they did not otherwise act in a faulty way. The problem is something is non-law based, so it's very blurry, of course, and allocating liability based only on policy considerations can be tricky. It can be like impracticable based on another member state's court system. But I found it when I was doing some research on how to apply existing concepts. I found it quite striking to actually find this, and it has earlier been applied to someone taking risky excavating activities and the like. And some Danish researchers said it's not completely far-fetched that it might in the future be applied to very high-risk AI applications, or something that could be considered if someone uses a prohibited AI system, because prohibition doesn't mean a prohibited AI system will not be used. Then other approaches in French law, you have the liability for damage caused by things that you have under your custody. So could these be bases for negotiation in the future? And I agree very much with what has been said both by Mindy and by Miriam. What exactly do we want to regulate? Is it possible to have a one-size-fits-all approach? Because we did see that there were difficulties when the AI Act was still a work in progress, and suddenly ChatGPT appeared, and the legislator had to go back to the drawing board. So if the EU legislator wants to pursue the project of regulating AI liability, one recommendation, instead of saying, should we regulate it this way, should we regulate it the other way? One recommendation that I would give in any case is not to rush it, because if legislation is too much is too badly rushed, then we might miss important points. We might try to push a certain approach, and then later on we find out it's not feasible, it's not compatible. So yeah, that is my main takeaway. If they want to regulate it, try to find a common ground. Do not rush it, and probably also wait how the AI Act actually being applied. What is the outcome of certain court cases, if there are in the future, regarding the AI Act? We do not have any harmonization on AI liability now. We probably will be able to manage a few more years without it, and then having a solid regulation that provides the legal certainty that we need for all stakeholders involved, and that makes it easy enough for injured parties to obtain compensation. Thank you.
Thank you very much, and I will ask you also a question on the chat. Please, the speakers, react on the chat as well. I will not take all questions here, but perhaps every now and then I will take one. So please react with the participants on the specific questions on your talk. I just found an interesting one. Do we know how much, and I'll ask this to Beatrice, since you are working on private law, do you know how much variety there was in the product liability between member states before adopting the PLD? Because I think it refers to the importance of legal history. What can we learn from the past when regulating AI? So what is your view there? Very shortly, was there a difference between the member states on product liability? Also, perhaps Miriam can touch upon that later, but what is your view on that?
Well, without having too detailed knowledge on member state laws pre PLD, what I know as a German lawyer is that one of the main issues before that was to prove the producer's fault, because under paragraph 820 of the German Civil Code, there were of course certain duties also for producers, but it's of course it's fault-based liability, and the initiating case that triggered this procedure of harmonizing product liability was actually medical liability scandal based on a painkiller that was supposed to be safe for pregnant women, but they got then severely deformed children, and they tried to get compensation, but as they could not prove anybody's fault. It was the thalidomide scandal. So, and I assume, as in many European countries, the basis of tort liability is fault liability. There may have been similar issues that if you have a defective product, you had to prove someone's fault.
No, indeed, and I see really a lot of interesting questions. I thought my role would be difficult to come up with questions, but the audience takes care of that. And even Shu already asked 2 open questions, making my job even like I can be replaced by a chatbot here. No, thank you very much, Beatrice. And also I see some interesting questions, so please do respond. I also have already some things to think about that I will launch now before I give the floor to Philip. What is the role of regulatory sandboxes? What is the role of testing environments to develop these evidence-based policy making? Because I hear this a lot, and we need to not too far, making sure there are gaps. What is the role of experimental legislation in covering, finding those gaps when it comes to liability? Another question, disclosure of evidence. Is it meaningful? Do we need not just disclose information and we leave it up to the weaker party still to interpret it and so forth? What is what is meaningful disclosure? Also, the defectiveness we mentioned by Shu, the product's defectiveness, and we all know the defectiveness test, not providing the legitimate safety expectation. But what does it mean concretely in an AI context? What kind of safety expectations can we have? We'll come to that later. We'll come to the questions by the audience, but I'll first give the floor to Philipp Hacker. Philipp, the floor is yours for your 10-minute speech on reacting on what has been said, your own view. So please open your mic and the floor is all yours.
Great, thank you so much. I'll try to speak fast as always. and be trying to giving a timely answer here. So I very much agree with a lot of the perspectives that have been voiced here, even though they're quite different in nature, because I think if we had a little bit more time, we'd probably agree on a lot of things. So just to make sure that I'm not misunderstood, when I said that the ALD was a missed opportunity, I did not mean to defend the ALD as it was. I think it was a fairly misguided proposal that, however, presented an opportunity to conduct a serious inquiry with stakeholders in an open setting to create something newer and better. Now, I think I want to tie together maybe some of the points that were raised by the previous speakers, including by Miriam, who basically answered the $1 million question. Who asked the $1 million question? What is it really that makes AI different, that would prompt us to even speak about AI liability, as opposed to the liability of the horse, for example, as to take up a famous example. So I think there are 4 points that I want to relate to here real quickly, and those are enforcement and the power asymmetries, the value chain, and finally agentic AI. So what are these going forward? So first of all, I think enforcement is not entirely different, as Mindy mentioned. It's not entirely different from other complex systems. And of course, tort liability, product liability particularly, has always dealt with highly complex machinery, particularly complex in the view of the time in which they were produced. Think of vaccine formulas, think of highly sophisticated rule-based algorithms that are not AI, or think of types of machinery like launching vehicles, SpaceX rockets and stuff like this. So this is not really something new. Absolutely, I would fully agree. Now, the problem with AI, I think, is that oftentimes you don't even know if or when you're being harmed. And that might be similar to other fields where if you get turned away, you want to enter a club. So I'm in Berlin, oftentimes people try to enter a club, and then you're turned away and you wonder, was it because some of my friends, they're having migration background. So it was because I'm Black, or was it because really they didn't like me? They didn't want me in the club for other reasons. So oftentimes, even if it's not in an AI perspective, you wouldn't know, is this for this or that reason? Now, the big boon with AI, of course, the big advantage we have is that you can actually audit these models, and you can actually kind of look under the hub, which is something you cannot do with the bouncer at Berghain, one of Berlin's famous clubs. So I think here lies an opportunity to actually go for some significant and serious enforcement rules that have been worked out already and that are in place on the PLD that were foreseen in the ALD. And of course, all of this can be done in an even better and nicer, whatever way. But I think expanding at least the PLD rules to the fields where Gen AI is wreaking most harm, and that is discrimination, personality rights, IP, professionally used IP, all of these fall outside of the scope of the PLD. I think that is quite a no-brainer. I can't say a no-brainer because, of course, there are arguments against that as well. But at least if you accept that we have that in the PLD, I think there is few arguments that would convince me not to expand this to these other fields where the harm is sometimes even much more serious than if you get your holiday pictures deleted, which does fall under the PLD. Now, that's the first point about enforcement, which I think is really crucial in this area. Now, second point, power asymmetries. We do see that there is a distinct political economy in the AI field, I think, in the sense of the way in which scaling works, the way in which value chains work. Again, we have oligopolies in other fields of the industry or other fields of the economy as well. And it's primarily, of course, the goal of antitrust or competition law to take that into account. We have the DMA, and it's not without reason that particularly the Trump administration is trying to fight against the DMA and not so much against the AI Act, because it is actually an instrument that has a lot of power besides the DSA, of course. Now, what I would suggest, however, is that good antitrust or competition law rules and enforcement needs to be accompanied with a scheme of unfair contract terms, directive, an update perhaps, in the B2B context. Because right now we're seeing that a lot of the power asymmetries that were or information asymmetries and actually market failures in the market for conditions that we saw and were triggering the initial unfair commercial terms directive are repeating themselves in the AI field and in other fields as well. But I think that would be a good first step. And we've seen some of this already included in the Data Act. So again, some of these shields banning recourse veto or recourse ban clauses, I think that would be a good way to start. Having a conversation about what might be limits to contractual power within AI frameworks. Now, that leads me to my third point, and that is the value chain question. And here, that's where I think that's what I think really the biggest question in practice is at the moment. So I'm doing quite a bit of industry consultations also, and the main question that really pops up all the time is, how am I liable if I only do fine tuning? It's a little bit unclear in the AI Act, and it's also unclear under, or at least complicated under the liability framework. Because unlike with traditional products, of course, with AI, and particularly with AI, with Gen AI, but also other AI systems, these systems can be adapted through a multi-stage approach and various levels. And the question is, who is liable for what? And I think a good way to summarize this is a judgment that was handed down in Germany, I think in the year 2013 or 2012, end of 2012. It's called the autocomplete case. And the autocomplete case is a case by the German Federal Court of Justice, so the highest court for civil law. We discussed this, by the way, in a new paper of ours that's forthcoming. It's called Generative Discrimination, with Sandra Wachter and Brent Mittelstadt and my fantastic colleague Frederick Borgesius. So the deal is that was a case about a small language model, Google Autocomplete. And if you are German or somewhere near, you might know that there had been allegations, rumors about the then wife of the German president, about her past as potentially a prostitute. So if you typed in her name, the autocomplete suggestion would be prostitute. She did not like that. And so she sued Google over it. And the court in the end, well, in the end, it decided a different case, but it was exactly the same track line. The court said, well, what Google needs to do is not that it's going to be liable for each and every of erroneous or potentially damaging autocomplete suggestions, but they have to take reasonable precautions to make sure that these autocomplete suggestions are not going off the rails. Now, this leaves me with 2 or 3 important points. First, there is, of course, a regime in place in member states, and I suppose that most other member states in the EU have a similar regime for protecting personality rights. Note that in the US, this might be a lot trickier, which is why we have Kevin Werbach and others on board here, fantastic people who know this much better than I do. But of course, there is no general personality right in the US, for as much as I know. And this is also a question we come back to afterwards. But in the EU, we have substantive law to deal with this. But again, it's dispersed over 27 member states. And it would be, I think, absolutely horrendous if each member state said something different about the different actors in the value chain about what they have to do in such cases. The limits of the Google Autocomplete case are that Google was both the provider and the deployer. So it was not a value chain case. And so you have to think about how that actually integrates into the value chain. And long story short, I would say that there is a tort law duty, general duty, to just make sure that you don't harm, to take reasonable precaution not to harm anybody. And this needs to be translated each and every step of the value chain, and potentially with safeguards at the provider level, certainly some reinforcement learning with human feedback at the moment, which is state-of-the-art technique, but then also going down in the sense of not taking down guardrails, not fine-tuning in the sense to remove this, making sure that you have pinpointed, perhaps even samples taken and some kind of red teaming done even on a deployment level if this is a particularly serious case. Now, so I'm just saying that this going forward, I think, is going to be a major question, and that brings me to my last point: agentic AI. Agentic AI itself is of course a big buzz in town. It's not fundamentally different, I think, from many of the other AI engines that we're seeing and mechanisms. But what I think it points us to is that the link between a system, and I'm finishing with this with my 10 minutes, and the people behind it. And I think the real question we have to answer is, how do we attribute actions and knowledge, or facts or non-facts, from a neural network or from some kind of AI engine to the entity behind it? Because that's the problem with agents that we have in agency law, just general humans, and that's the same problem we'll see now with agentic AI. But not only with agentic AI, with all of these other engines, the problem is mostly one about attribution and about the right duties of care for reasonable damage prevention. And I think those are some of the fields that I would certainly be curious to see more research on, and going forward, hopefully also more policy work from the EU and beyond. Many thanks.
Thank you very much, Philip, for your four key takeaways already. And I like the focus on enforcement, because indeed, not only with the liability framework, but also the AI Act, the questions of enforcement. Yeah, you can have the most beautiful law, but if it's not properly enforced, then it's a bit useless. We all know that from GDPR experience, for example. So I think the focus on enforcement is right. It's also the supply chain. Perhaps like just because if I may, I'll ask you, there's some questions on generative AI in the chat, so please feel free to follow up. I also see that Shu got a question there on the effectiveness. But to Philip, the supply chain, I like the idea a lot, but would you then require also legislation covering the different actors? Or do you say it's something we have already, and duties of care, we have them already? So new legislation, how do you see that very shortly?
That's a great question. I think this is so the value chain is ever protean, so it's really changing a lot. And I wouldn't see this as a matter of legislation, other than a sketchy framework. For example, in the AI Act, you have some notions for what is happening when there is fine-tuning. Now, fine-tuning is the adaptation of a model. I think this is something that we will see even in the future, even under different paradigms. Even if we leave the transformer architecture, we'll still have adaptations, because it's just economically efficient. And thus, seeing something about the originator, developer, the adaptation, and then the final deployer, and perhaps the end user. I think those four entities, covering those, that would be good in legislation. The rest can be left either to technical rules and standards, or the courts, and guidelines, of course, from regulatory agencies. But it's sure that you cannot do all of this package in Parliament and revise it every 5 months or so.
No, thank you. And you brought up another point for the questions later, is the role of the courts, because eventually tort law, they play such an important role in concretizing these concepts. So this will also be a question for follow-up. Miriam, I think you're the next one, and I see there's a lot of speakers. Thank you, Philip, by the way. And I see there's already a lot of questions on the product liability directive and those of defectiveness. So please, you did a lot of research on that. So the floor is yours for your 10 minutes pitch on AI liability, the way forward, and what's happening, what should happen. Please, open your mic.
Thank you, Jan. So far, I found it really inspiring what everybody is saying on this, and having such a deep discussion on this. So indeed, actually, the reason I got into the product liability directive was actually we were doing a project on the AI liability future. And one of our first conclusions was there is no point in talking about this before knowing what is already covered through product liability. So that's how I ended up there. So I would like to make 3 points already diving into this question of what do we need to know about the problem, and then make a few points on harmonization. So first, these 3 points would be defining the problem carefully, identifying the gaps, as Mindy also mentioned, allocating responsibility to an entity for the actions and decisions of an AI system, as Philip also just mentioned. And then the third point there is, I believe it's very important that we consider the different types of problems when we have a fully autonomous system that is supposed to work fully on its own, or a system where a person is supposed to work together with a system. Before moving to some of the harmonization and enforcement questions. So on these 3 points, first, we need to define the problem, right? As I already mentioned, if we want to devise a solution, we need to know what is it that is so new and salient about AI that requires a change in liability. And often, of course, we've heard also from the start from the European Parliament, right, this list of it's complex, it's opaque, it's data-driven. But then the really key one, in my view, is that it can act autonomously, right? We know already also of other products and systems and situations where we deal with complexity, with other technologies in the medical world. Courts are, they have dealt with situations where we don't know exactly how something works, or it's difficult to understand. And we have all kinds of ways from expert testimonies to disclosure rules to help courts determine responsibility there. So that is not something that is revolutionary, right? We do have the fact that AI is data driven, and that so if there is an error in one system, we may need to consider the fact that that error exists in all of those systems, right? Let's say different from a manufacturing failure in a system. So that is something that does matter. But then the big thing is that an AI system may do things that are not foreseeable, neither to the company that made it, nor to the person that uses it, right? And that is the key issue, I would say, where we say, okay, national liability rules may not be able to deal with that, right? If we have strict liability and somebody is liable no matter what, then it may not be so important. If you use the system, you're liable. But as soon as we talk about fault, it becomes quite difficult to define what is fault if you cannot know what the system is going to do. And that is, as Beatrice pointed out, something where maybe vicarious liability is relevant. And then maybe we should think about this as in, just like you may have a dog and the dog may act in an unforeseeable way, your AI system may do so too, and then you're liable. But still, the question with autonomy then is who is responsible for that, right? So that brings us to my second point on how to allocate the responsibility to some entity behind the AI system for its actions and decisions. And a key element there is simply dividing or allocating the responsibility between the producer and all the entities that may be part of manufacturing, which is a question on its own, part of the PLD as well, and the operator or the user. And so here I really do think that the product liability directive needs to be the starting point, because we need to identify where are the gaps, right? Theoretically, we could say as a producer, you're just liable for everything that goes wrong with your AI system, and then we sort of solve the problem, right? An economist would say, then they're just going to insure themselves for this, the customer is going to pay for this, and that would be relatively simple. Right, but there are also good reasons why we want the operator to be liable as well, right? We want them to be incentivized to use these systems safely, to maintain it, to not use it in situations where it's not appropriate, right? As Shu pointed out, that is something that we need to consider. So we do want some responsibility for both, but now we need to ask, how far does the responsibility of the producer extend? And the revised PLD does clarify some aspects there. We've also already talked a bit about defectiveness, or when is a product defective. This to me is a really key element, because if we think of a very traditional product, right? If we use cars for the sake of simplicity, you might have a car where some, little screw was missing in the factory, and so the brakes are failing, right? A manufacturing defect. With AI systems, we can expect that much more often we will rather be thinking about a so-called design defect, right? The system was not tested in the right circumstances, maybe not for bad weather, or maybe there was a failure in informing the user, oh, you need to take over the wheel now, something like that. And that would be a failure that is much trickier to assess, right? At what point is that the case? How good do you need to inform the user, right? Autonomous car users still really like to sometimes, not pay attention when they're supposed to. What is the responsibility of the producer to warn them, and where does the responsibility of the user start? And with defect, in terms of design, it goes even further, right? How perfect does the system need to be before we say it's a good product, or put vice versa, right? At what point is the system not safe enough, and do we say, okay, here it is defective? Because that is going to determine a lot also of at what point a user or an operator would take over responsibility, right? And here we might think of a failure rate, something like that. We might want AI systems to be at least as safe as non-AI equivalents, if there is any. right? Sometimes there might not be any. Maybe we don't want that, right? Maybe the types of mistakes it makes are different from the ones that humans make. We certainly don't want to get to the point where companies are not using AI because their responsibility would be so much bigger than for the non-AI system, even though overall they're actually safer products. So this is something that we need to think about a lot in terms of how we interpret this, what we want in terms of balancing the adoption of AI with the safety of AI. And that's not something that liability can solve on its own. There we need regulation like the AI Act, but also sector-specific rules to set some minimum standards of what the AI system should do, right? So technical standards, I think, are very important here as well. But so this defect is going to say a lot about the circle of influence and responsibility of the producer. And then outside of that, it would be the operator or the user, right? I mean, we could certainly imagine cases where maybe we wouldn't talk about producer liability at all, but often it will be a bit of a balance between both. So there is a foundation in the PLD, but it's not a complete solution because we want to have cases where we want the operator to be responsible. And here we then get to this third point on fully versus semi-autonomous AI systems, right? If a producer markets a system as fully autonomous, the user doesn't need to do anything, then we could also say, well, in principle, the responsibility is with the producer, right? Not a major liability challenge here, but most of the time or all of the time, there will be some situations where the user has to do something. If it's not constant monitoring, it will be maybe using the system not in certain circumstances or maintaining the system. We could think of something simple as, a robotic lawnmower. It's not appropriate to use it when little children are around and you're not, watching the machine, right? Possibly. That's something that a producer, of course, has a very clear interest in warning about as well, right? So to avoid liability. But then when we have these semi-autonomous AI systems, there we have this question, right? I think the medical context is really one where we could imagine a lot of concrete use cases where this might happen. If a doctor relies on a diagnosis or a treatment suggested by an AI system, should they always check this? And if they always have to check is, do they have any benefit from using the AI system, right? Is it going to take a lot of time for them? Or should they be able to blindly rely on it? When should they question when the system is sort of hallucinating or doing something, making an error? And here we then have to ask, at what point is, for example, a physician or a hospital at fault for not doing that properly? And now the question is then, of course, who is going to decide on this question of fault? Is that something that we want to leave up to the courts? And if we do that, then we're going to, of course, get different outcomes from different courts in different member states, but also just different courts in the same country, right? Or do we want to guide that somehow? And if we guide that, can we do that in a way that really provides uniformity? Because one thing that we really need to be aware of is that in liability, there is no sure thing, right? It is very context specific. It should be very context specific. We always need to consider the circumstances of the case. And that means that we shouldn't expect that if we have some sort of a EU framework that firms always know when they're going to be liable as operators of AI systems. That is simply not something we can expect that's inherent to tort liability. So that then brings me to my final point of this harmonization question. I have 1 minute.
1 minute, yes.
Yeah, okay, good. That's fine. So here we then have to ask, okay, what if we try to clarify conditions for fault or provide some minimum standard for the burden of proof? What are we going to achieve with that, right? There is no one-size-fits-all solution. AI systems cover a wide range of settings and contexts, strict liability, fault liability, so we cannot just set one rule for that. We might want to clarify the conditions for liability, but that's all we can do. Same thing with the burden of proof, right? As Mindy has pointed out, there are already many ways in national procedural law that courts can get access to information, and maybe that's enough, right? So when we then consider the next steps of where should we go, maybe it's not so much a regulation where we try to do the thing the AILD did in a better way, but maybe it's guidance on conditions for fault that help courts. Maybe it's mandatory insurance for certain AI systems that are very risky. Maybe we just need soft law approaches and collaboration between member states to find some common ground. What types of AI systems require strict liability, for example, right? Maybe we need to move more towards this common ground of what type of liability we need before trying to prescribe anything. So that it would be my final word on this, right? We need more understanding of these conditions that ultimately are going to guide the courts in practice, rather than trying to create one size fits all perfect framework that's not going to do much on the ground. Thank you.
Thank you very much, Miriam. And again, I hear the claim, the supply chain allocating responsibilities to different actors. When do you stop becoming producer and user? I think that's something that I find very interesting, that you also have in line with common with Philip. I also hear the multi-level governance, right? I mean, like multi-level governance concept from political science, but it's increasingly becoming used in law as well. Regulating at different levels, multi-level governance in EU, I think that's also the way forward. I will ask you one question, and I see that there's a lot of things are happening on the chat, which is of course great. Miriam, one question to you, and then afterwards I'll give the floor to Mindy. What is the role of, because this is out of my own interest, of course, if you have an AI system that is certified as being safe and perfectly fitting all, what is the role of the certificate in the notion of effectiveness? I think this will also become very important because we have standardization, certification. These systems will need to be under the AI Act, certain provisions on certification, be certified. Well, how does this affect the qualification of effectiveness?
Right, so thank you for asking this. So this allows me to say, this was the conclusion of one of my papers on product liability, that this should be linked more clearly, right? Because so far it's about consumer expectations and effectiveness, and that's a very blurry concept when it comes to autonomous AI. So the PLD does link with the rules for the regulatory rules, that gives then a presumption of the AI being not defective, let's say, if you comply with that. And I think that's a very sensible approach, right? Because that actually then provides some legal certainty to companies. Once we do this, then we're sort of safe. But of course, then again, you still have to be able to account for the concrete circumstances of the case. So I think it can provide useful guidance if used appropriately for court cases, to link defect and regulatory requirements. And it does in the PLD, yeah.
I always find that my PhD quite a long time ago was on certification, hence perhaps some bias as well. And so I find it a very interesting question, the role of certificates in qualification. I do have other questions, and perhaps already I will launch them for the Q&A. A lot has been mentioned also on the quality of data, right? Should we not go towards like data liability as well? Like I know there's a Data Act and stuff, but should we not go towards like more the data, because quality of the data is so essential? Data liability, I don't know, something that could be thought about. Also, I like the ideas of guidance that you mentioned, Miriam, and guidance to court judges, making sure that they also have a common understanding, soft law. Perhaps we can already think what should be included in this kind of guidance. What is meant with a fault of in an AI context? And I also see that someone asked for the relaunch of the proposal operators liability by the European Parliament. I think that's an excellent idea to really reconsider that as well, considering that in the situation we are now. Thank you, Miriam, and please, I will come back to you with some questions as well later. But now, first, finally, the last 10 minutes pitch is for Mindy. Mindy, please open your mic, and I would assume that you will touch upon medical malpractice, perhaps, the sectorial approaches. But if that's not the case, that is also perfectly fine. If you want to react on something that has been said already, please go ahead. The floor is yours.
Yeah, thank you, Jan. So just to apologize in advance for a little bit of being all over the place, because I had something prepared. And I assumed this would happen, which is that the speakers before me have made really excellent points. So I'll try not to repeat some of that, but I may build on it a bit, which led me now to having these chaotic notes for my 10 minutes. So just bear with me. But I thought it might be useful actually to start out by talking about the elements of liability for strict product liability under the Product Liability Directive, and at a very general level, and the elements of liability for fault-based liability, because I think that it's important to one of the points that I'm going to make about where the focus lies in these two types of liability. So for product liability under the PLD, so strict product liability, there needs to be a defect, causation, and damages. And for fault-based liability, of course, there needs to be fault, causation, and damages, right? And there's a distinction also, I think, that needs to be made between safety regulation, and sure, it's connected to liability, but it is not the same as liability, right? So when I hear the word enforcement, for example, I think of like regulatory enforcement. And in fact, even when I hear the word regulation or regulating liability, it kind of makes me, because I'm like, it's not regulation in that sense. It's not ex ante, right? Of course, it can be in a regulation, liability rules. But what's happening ex post in a liability case is not just the kind of normative, is this defective or is this safe or was something reasonable, but did that cause the damage that's being claimed? And in terms of damage, I think Shu always covers this wonderfully. And also Philip brought up some great points about the different kinds of damage and maybe new damages we're seeing from AI. But I kind of think myself, and I maybe challenge everyone to think about what kind of damage should we try to prevent with safety regulation, and what kind of damage should we focus on compensating in a liability regime? Are they the same? Like, are they different? Should we place more emphasis in one place or another? Because inevitably these things work together, but they aren't the same. So thinking of liability in private law, I'll move there now. So I try to think about Miriam's question as well. So what is unique about the challenges that AI presents to liability that we don't see in other sort of from other contexts, whether human behavior or product liability, right? And to me, well, there's a few things, but I'll focus on one, which is the focal point of the liability assessment. So there's sort of two main focal points. In product liability, we're looking at the product itself. We're looking at its characteristics, and we're looking at its what it's made out of and how it was designed and how it was put together. And it's sort of, usually static, and that's one of the challenges we get with AI. But we're looking at the product, and that is the focal point for the assessment. Is this product defective? For fault-based liability, we're not looking at the AI anymore to ask if it's defective. We're looking at conduct surrounding the use of the AI that led to the injury. We're looking for fault, and fault is assessed under behavioral standards, right? Usually, let's say reasonableness or something around reasonableness. Was it reasonable under these circumstances? I think someone asked in the chat, and maybe I could just kind of pick this off right now. Like, are there different kind of sector specific liability rules? I think my main answer would be sort of no, like at a general level, and I think there are in some cases, but what we find is that reasonableness means something different for a neurosurgeon than it does for a cardiologist, than it does for a driver of a vehicle, than it does for someone working in a warehouse. And when that standard of reasonableness or the standard of care or standard of behavior that we expect require some sort of special training or experience, then we have to rely on experts to kind of tell us what is reasonable in those scenarios. So things can get very, very complex there, beyond just the medical sector, right? I mean, I think the most challenging deposition of an expert I ever took was of a metallurgist who talked about the properties of metal in a very kind of clear, car rear wheel axle, braking, kind of like if I had to think of like a product liability, like a wheel falls off a car. Like, so, that's something we're like, oh, that's super standard. But that also got extremely complex. And it wasn't one of the doctors that I had to depose about, how kidneys function. It was about how metals function in the world, right? And so there are, there aren't like different liability regimes for every different sector, but our liability rules are supposed to be flexible enough to encompass this standard of behavior. Okay, so this leads me to what I struggle with, or at least what I think I've determined as what AI presents in terms of a challenge to liability that we haven't seen yet. And to me, what it is that AI can exhibit both characteristics of a product where we can sometimes judge it, like Okay, how was it designed? What materials or data were used? Were they bad? Was it good? You know, in that case, like, and it can exhibit some very product similar you know, conduct or behavior, but it can also exhibit behavior that we normally see from humans and that we normally judge under a behavioral standard. But we can't judge AI under a behavioral standard because it's not human and it's not a legal person. So I want to make this point as well, which is that we have a robust system of liability for organizations because they're legal persons, and we accept that they can behave and that their behavior can be subject to behavioral standards. And so, as Philip pointed out, we expect that they are reasonable in the way that they adopt and implement technologies or tools, or reasonable in the way they select doctors to work at their hospital, or the way that they train nurses. And if they're unreasonable in these ways, they can be held liable already, right? Under our tort system, or contract, if you're looking at kind of negligence in a contract sense, for example, like, in cases that focus on a treatment contract for doctors. But what we don't have quite, I think, is the ability to judge behavior by an AI. And so then that puts us in this position that Miriam points out, which is now we have to say, is it defective? And we don't say that a human is defective when they do something negligent. We say that that behavior was substandard, but we don't say that human is defective and everything they've done before and everything we do further will also be defective, right? And so to me, this is the unique challenge, or one of them at least, or to me, the main one that AI presents to our liability frameworks. And it's good, and as other people have already pointed out, that product and fault-based liability are not mutually exclusive. You don't have to choose one or the other. And so Miriam makes this wonderful point about how are we going to allocate? How are we going to say, well, this is a defect versus this is some sort of human behavior that was negligent. But I think what falls into the gap is this kind of AI behavior that maybe, how do we judge that as good enough or negligent? Well, we can't do that now. And to me, this is the kind of the big question that always resonates in my scholarship thinking about liability, because I think fault-based liability, product liability, the tort system, it's already pretty like resilient in the sense that you can sue a lot of different people in one case for the same injury for lots of different reasons. And however that can be allocated, or whether you can kind of get a reduction at that moment, or you need to ask for contribution later on, that's all procedural, right? It's a pretty good system for saying we recognize that a lot of different constellations can lead to an injury, and we're ready to kind of assess these things, whether it's a defect or whether it's negligence or whether it's from a human or an organization. I think what we overestimate a bit with AI, a couple of things. One is the ability of humans to check it. So especially in the medical sector, oftentimes doctors are using AI because it gives a new insight that they could not get on their own, right? Because they can't see inside of a vein. But they can insert dye, and AI can perform some calculations to say, hey, you should cut here and not there, or take a little bit more tissue because this appears to be cancerous in the way that the blood is moving through the vein, right? And so these are things I think we need to think about, like how much are humans capable of overseeing AI? I think we overestimated that a bit, at least in the beginning. And then also, I'm not ready to accept that AI is a dangerous, or high risk, like just across the board. Can it be? Absolutely, it can be. And it can be like dynamite or a pit bull or whatever. And we can say that some systems, hey, look, we have a system of strict liability for inherently dangerous things or unreasonably dangerous activities. And maybe an AI falls in there. But I think oftentimes it won't. It's just not inherently, like bad, like, or dangerous, like using dynamite, for example. And I worry that we're ready to kind of attach liability strictly or vicariously, well, or strict vicarious, because we need to find a place to put it. I worry about this. I worry about doing this inside of the tort system. because we need to not just think about, oh, how can we compensate an injury? One, we need to think that not all injuries are compensable, even now, under our tort system. Right? So that's one thing. But we don't need to just compensate an injury. We need to think about how this liability fits within the theoretical and doctrinal frameworks that underlie our fault-based and product liability systems. Because if we just give liability just because it has to go somewhere, then we could be betraying a very core doctrinal principle of that system. And I don't think we want to do that as lawyers, right? There's so much across the board that I agree with, but I think we need to consider how we're going to deal with this kind of behavior. We can think about it in terms of maybe risk management. We pull from the safety regulations and say, hey, we need to really focus on the behavior that's supposed to prevent or mitigate risks. I think a wonderful solution would, of course, be to have some sort of no-fault system where it's handled via insurance. But that requires huge structural change, and I don't know if that's practical, or maybe it's not even desirable. I don't know. But I just think we need to be a little bit cautious about how quickly we point a finger and create like a liability sink, because I think it can have unintended consequences down the road. By the way, not just for AI. So I will wrap up there. Wait, let me check my hectic notes to see if I had anything. Well, unless I'm over time, Jan, then I'll shut up.
You don't have much longer. I'd say it like this in a diplomatic way. But you brought up a lot of stuff already, yeah, and especially focus on the reasonableness, behavioral standards. I think it's also Borghetti. I think he wrote about it, the reasonable AI system, in one of these books of Lawson, I think. No, but thank you, and also there's some interesting perspectives that I like to. Also, the importance of humans. Humans also mentioned there. So I like that a lot. I will first give the floor to the speakers, because I see some interesting questions there. Are the speakers, does someone of you want to react, say something, add something? We now have a kind of open floor, so please react to each other, or some questions that have been asked in the meantime. Yes, I will do it indeed, raising your hand very shortly, because this will, for the moderator, be more easy. So Philip, please.
Yeah, thanks. Those are great points. It's really intellectually stimulating to listen to all of these wonderful presentations. Now, one of the things that particularly piqued my interest was the question of what is the unique characteristic that, or one of the unique characteristics that sets AI apart, if anything, and B, what follows from this in terms of the architecture of our tort systems and the way we conceive of liability. And I'm not, in fact, on the one hand, I want to reiterate what a lot of speakers have said, particularly Miriam and Mindy. It's like, this is not something that's very unique. It's not uniquely opaque. It's not uniquely complex. And so the discussion focused a lot on autonomy then, and Mindy, for example, made the point about, the behavior versus the incident. So where we're looking at the specific, at the whole product, or only at that specific act, let's say. So I think some of the problem might be actually encapsulated in the anthropomorphizing nature of language here, because at the end of the day, I think we have, I'm not so sure that we have really qualitatively different foreseeability issues with AI than with other products. In fact, when you have autonomy, it just means that that, of course, without human intervention, the system comes up with some kind of decision or output that was perhaps not from the training data, for example, that it's somehow learned to do. But in the end of the day, that only means that there were a series of steps. There's a series of steps that was pursued to come to this output. Now, this series of steps is very complex, of course, and it's impossible oftentimes to know in advance what would be the outcome. Nevertheless, most of these systems, Gen AI not, but most of the systems are deterministic. So you give one input, you have the same output all the time. You might not know before what that output is if you do it the first time, but most of the time it's deterministic. Whilst in for example, in medical settings, we have similar things. So I come from a family of medical researchers, and you, if you do genetic engineering on pathogens, a lot of the time you have no idea what's coming up for this, which is why we have strict liability, by the way, in these frameworks in genetic engineering. But I think also if you look at vaccination and other complex products, you have oftentimes down the road effects that you couldn't perfectly foresee. In fact, there's a whole field of course complexity theory that looks at mathematical ways in which I took some of these classes when I was a student, fairly simple equations that can get you to extremely complex behavior that's entirely unforeseeable. So what I want to say is that I'm not even sure that autonomy sets AI apart. So what is it then? I think that it is a degree of unforeseeability that might not be qualitatively new, but it is still so pronounced that we need to have a good vision and a good system for making sure that we define the precise points that you mentioned, such as effectiveness and others, or fault, within that framework. And what that means oftentimes, I think, is to learn much more from other sectors, such as medical regulation, about pre-market testing. Because if you look at the AI safety literature, a lot of the literature recently, very recently, has pivoted to a much more empirical design, including, for example, the suggestion of confidence intervals when testing large language models. Now, the problem with LLMs and Gen AI, of course, is that you have these random variables in there that make them non-deterministic, so it makes it all the more complicated. But basically, I think we need to come to a system where the question oftentimes will be, did the original provider use the kind of state-of-the-art testing framework? There's red teaming, semi-automated red teaming. There's a lot in the works right now to make sure that this is a product that at the system level was safe enough to be released. And of course, there will be differences between product liability and product safety. But ultimately, this is also the question we're going to have to ask at each step of the value chain, because there's going to be different red teaming / AI safety mechanisms at different stages of the value chain. And if we get, if that's one starting point, I think that makes for a really interesting interdisciplinary research between computer science and law. And second, it also means that we can learn a lot more from the testing of complex products in the financial world, in medical sciences and engineering for AI going forward, and for the questions of tort law and how they are being handled there. And in fact, to end the story or end of my comment, I'm not even very much convinced that we need a whole new framework for AI liability. I think current systems can get us very far. Where I would be cautious is to say that this is actually the most efficient, the most effective way of doing it, instead of having a more overarching regime that guides courts at the EU level. But that is something to be discussed going forward.
Thank you. Very interesting points you brought up, and I know we only have 2 hours, but it feels like we should do 2 days of this. I think we can fill it with comments and with interactions. Thank you, Philipp. And I also understand there the expectation management, right? Is something like it's also quite important. In addition to the interdisciplinarity, learning from sectors, from other disciplines, to come up with if needed, with appropriate regulations. Does someone from the speakers want to react? Because perhaps someone from the start, Shu or Beatrice, since you were the... I see Miriam, I don't know, please raise your hand, Miriam, please, the floor is yours. Shu and Beatrice and Miriam, if you want to act, please raise your hand. Miriam, the floor is yours.
I will keep it short also, indeed, to give Beatrice and Shu a chance. So I see what you mean, Philip, and I do think that ultimately, like, if we would really, the better we understand the systems, the less it's about unforeseeability, right? I mean, the more we know, the less is unforeseeable. But I would say that it is different from what we know from, in medicine. Of course, there's a lot of things we might not know about, but a lot of the systems that are being created now are purposely being created in a way that they should themselves find out how to get the best way forward. So I do think that we have a shift of control in terms of that the aim is not to create something that we do fully control. The aim is to create something that itself finds the best solution. So that to me is the qualitative difference to what we had before. But we can I find it valuable to hear your point on that. And I just wanted to align with what Mindy said about strict liability. I very much agree that AI is often actually not introducing a new risk. Often it's actually reducing risk. And we've traditionally thought of strict liability as a solution for particularly risky activities or products. Right. So to answer one of the questions on, revisiting the Parliament's proposal back from 2020, where, that idea of strict liability, that doesn't align with the notion that AI often will make things safer, or just solve a problem and not introduce a new risk. And that is why we cannot have this across the board solution of strict liability only for, let's say, car-like systems. I mean, if you fly a big drone around, then that might have that kind of risk. But most of the time it will actually not. It's a different reason why we are considering strict liability, and that is that we might not know how to allocate fault, but it's not the risk element per se. So I'll leave it at that.
Interesting, really interesting to have your view as well. Beatrice or Shu, does someone from you want to react before I give the floor to the audience again?
I could quickly pick up on one or two points.
Great.
Probably consciously or non-consciously, when thinking about this strict liability for AI or for a high-risk AI, as it was addressed in this 2020 proposal, probably some general underlying skepticism has been playing a part in drafting these rules, because for many of us, AI back then, and probably for many people still is something very new that we don't really know what is it capable of, what are the risks, what are the or not only risks, what are the dangers, and it's probably some reflects to, okay, we need to kind of limit it and regulate it in a more strict way to manage the risks, or to prevent almost any risk from materializing, very well knowing that it's not possible. We cannot. Well, if we want to take that approach, we also have to prohibit driving by car, because there are so many people still every year that die in car accidents. But it may or may not. I'm of course not able to read the minds of those who have drafted that resolution back then. Probably this strict liability for high risk AI, one could consider, if they want to revisit that proposal at some point, change that into strict liability for very dangerous AI systems, because was it I'm now not sure, was it either in the principles of European tort law or in the draft common frame of reference, they suggest some strict liability for abnormally dangerous activities. Probably take that up. Then also one very valid point that Mindy raised, these unforeseeabilities. And to what extent can a human actually oversee AI? This may actually be relevant not only for the question of liability, but maybe also for AI regulation. In general, right now, the AI Act requires a human oversight, at least for high-risk AI. To what extent is that actually feasible? It may be now, but if we go 10, 20 years ahead with a technological development, will we get to a point where a human is no longer capable of actually overseeing AI? And then that might also, if we can't oversee anything, then who can be liable? Do we need to revisit again the question of whether we should attribute some sort of legal personhood to AI and allocate funds to them, so
that would open Pandora's box, the legal personality to AI.
No. I say, should we? I'm not going into detail. Oh my gosh.
No.
I'm going to I put this here and leave it.
Okay.
Thank you.
Thank you very much, Beatrice. Shu, do you want to shortly respond or add something?
Just a very, very brief thing. I learned a lot, for example, from our speakers, especially Professor Hacker, and also Miriam also mentioned about this, let's say, liability from a supply chain perspective. I totally agree with that. We need to consider that, especially, let's say, joint several liability, so how to allocate liability along this supply chain. One thing, but this isn't my, I think is I'm considering might not be well addressed in the any liability regime, but also, for example, by other regime is how, for example, we collect the evidence along the supply chain. So, which means that how can we, let's say, if a supplier say that this is not my liability, it should be someone, let's say, in the upstream, and let's say he tried to recourse the right to have this right of recourse from other upstream parties. How can they access the evidence from upstream parties? So in that case, I mean, we have this evidence from the AI liability directive, but it helps the claimants, but it doesn't address, for example, for the parties in supply chain. And also, I think I did not do a research so far, but we need also to consider this, how it would be addressed or aligned with other, let's say, data sharing rules. For example, Data Act, I'm not sure. Maybe we need to look at how to make sure that such evidence or such data can be really disclosed without any problem. So yeah, so that is my last word about this supply chain liability things.
Okay, thank you. I see Mindy raised her hand. Please go ahead.
Yeah, just very quickly, maybe this is a place where the sort of US litigation culture could be helpful, which is to think about the discovery process within litigation in the US, where there are mechanisms for not only getting evidence or getting information from parties, like in the process of litigation, but also for protecting things that are disclosed in the process of litigation. So there are, just to say that there are ways to do this procedurally. Things can be kind of redacted, or they can be dealt with in camera or like in the judge's chambers. So there's like quite a lot of ways that evidence gathering can happen, while acknowledging that the US is sort of, I think unique in the way that it approaches litigation discovery, but there are some analogs, I think, in other systems, but it could be expanded to solve that problem, Shu. But I think it's a wonderful point.
About to say also disclosure in the United States could be a path forward as an inspiration. Before I give the floor to the speakers, a final time to really in 30 seconds, there one key takeaway from this lecture. I want to take one or two questions from the chat. One of them is, should we make a difference between the use of private actors and liability and public authorities that use AI? Should there be a difference in the allocation or things of liability? And of course, you can have a long discussion about that, but does someone from the speakers wants to share his or her view on that question? Should we make a difference or not? If no one wants to say something, I can also, or if Martin is there still. Yeah, go ahead, Phil.
Jan,
Philip, go ahead.
You've moderated so greatly. You go.
No. My role is to moderate. So please, Philip, share your views.
I think here we really have to differentiate between the product safety and the product liability framework, or the product governance and the product liability framework. Of course, it makes a big difference if it's a state. Think Elon Musk, state-esque actor using AI in some quasi or totally official fashion versus just a company. We're used to talking a lot about harms being potentially perpetrated or triggered by company behavior or individual humans, but we often forget in Western societies that if the state does something, that can have ultimately even much larger consequences, which is something that unfortunately I think a lot of our colleagues from the US side are learning in a hot way at the moment. So there, of course, you need usually much stronger safeguards when a state is doing, or a state official is doing something with AI than a private person. Now, having said that, I'm not sure that there should actually be a difference in if it is legally validly used, that it should be much of a difference in terms of liability standards. because at the end of the day, it's a human person within an organization that is, to a certain extent, hierarchically structured, that uses a tool that can somehow cause damage. And I wouldn't see why, for example, state officials should be held to a stricter standard than others. Now, of course, in liability terms, there are special rules on state liability, which make these things a little bit complicated sometimes. But I think this difference between what is allowed in the first place, AI Act style, and second, what happens to harm, that's really of key importance.
Thank you, and indeed, I think also there's like these state liability rules, but in Belgium at least the state is can be held liable. So I don't, I agree with you. I don't see a difference into why it should be different for the private actors and the public sector. I see some, and this answer brings me back to I think the first question in the chat, the difference between the United States. It touched upon that, but in the sake of time and making sure that that everyone can go to other meetings at 3 or later, I just want to ask the speakers in 30 seconds, really sharp to give their one key takeaway of this to the audience, but perhaps something that they learned or say something that is new. I doubt it, but perhaps your one key takeaway. And I will start with this time. I will start with Mindy. Mindy, what is your one key takeaway in 30 seconds?
So I think my key takeaway is that we should not sort of make any quick decisions about AI liability that can have lasting or impacts that are not ones that we want to see, or these sort of unintended consequences, that we truly need to think about what the problems are and whether or not our current liability structures or paradigms can solve them. And if not, then the best way forward.
Thank you very much. Miriam, the floor is yours for your one key takeaway.
My one key takeaway is to sort of just really do this bottom up, sort of start from the ground. What are the concrete problems, concrete use cases, the problems we will run into before courts, and then go back up and see, okay, what do we need? What are the gaps? What is missing? And then the final question should be, is that something to do on the EU level, and how to best do it on the EU level?
Okay, thank you. Beatrice, your one key takeaway, sorry, in 30 seconds.
Thank you, Jan. Well, I'm afraid I'm going to be a bit repetitive because I very much agree with what both Mindy and Miriam have said. So do not rush it. Figure out what exactly we need to regulate. Not necessarily everything that could be regulated, but focus on the essentials. And then carefully see how it could best be done. Is it a regulation? Is it a directive? Is it guidance documents? Thank you.
Stood from the 3 previous speakers already some common elements, bottom up, starting from gaps. Something that lawyers, that legal scholars like a lot. Shu, the floor is yours for your 30 seconds key takeaway.
Yeah, thanks, Jan. I think I learned a lot from this excellent workshop, but I think one word I find is very important, that is architecture of AI liability. So we really need to think about if we, let's say, have this AI liability across Europe, where we put it. And this also links to what Miriam and Mindy and Beatrice and also Philip mentioned here in all this workshop. So how do we link this AI liability with other legal rules? So what is the really necessity at this stage?
Okay, I like the fact that there's like really a common language. I am quite surprised to see that in the end, we agree. Philip, the floor is yours for your 30 seconds key takeaway.
Thanks. So first off, I like to stress that I think it's important to note that AI is just a very powerful calculating machine. And I'd love to discuss more, and also with computer scientists, the extent to which this is really a unique feature or qualitatively different or not from other complex systems. I think the jury's still out, and I'd love to come back to this, Miriam, maybe bilaterally at one point. And also, last thing, if we do this again, I think it would be beneficial to have scholars from the US, perhaps also people who are knowledgeable about Chinese mechanisms, because the really big problem then is international. regulation and compliance, because you have these regimes in Europe, which are complex enough. But then again, if you look across the ocean, of course, you have product liability in the US, you have the mini AI Acts at the state level there. And that's only the US. You have Canada, Brazil with their own regimes, both prescriptive and liability regimes coming up. And of course, the whole theory and legislation that is happening in China at breakneck speed. And therefore, I think it's time to open our eyes and horizons toward the international landscape and learn from them and from other sectors, and then proceed cautiously but firmly toward the best possible mechanism for AI liability that we will certainly find in 2025. Thanks.
All speakers, my one key takeaway is indeed, let's do it again. Let's have this webinar again, perhaps in person, a bit longer, because I think there's so many things still to discuss, so many issues we did not resolve, so many pending questions. We found some common grounds, but you hear the nuances are needed. Also, like the global perspective, what is happening in other sides of the world, away from this Eurocentric view. I think this makes perfect sense. I would, before giving the floor to the president of Rails for the closing remarks, I would like really to thank all the speakers. I think it's been really, at least for myself, a very interesting, valuable experience. I would also like to thank Alessandra, the media team of Rails, for setting this all up. And I would like to thank also the participants for their questions. I'm quite sure, feel free to reach out to the speakers, feel free to reach out to me if you have questions. I will share the slides afterwards, but really a big thank for all these insights, and especially to the distinguished speakers that joined me today. They gave their key takeaways, so this is stuff to think about. Closing remarks. Martin, the floor is yours for the closing remarks by the president of Rails. So please, the floor is yours, and thank you as well for being here.
Yeah, thank you so much. Actually, we had already two closing remarks, one from you, Jan, and one from you, Philipp, actually claiming that it is really necessary to have a follow-up webinar on this issue, and then also to include not only European scholars, but also US American and from other jurisdictions. I think that this discussion has really tackled a lot of different aspects, from why actually do we need AI regulation, how to define the problem, what makes AI systems different from other systems. Is it autonomy? Is it foreseeability? Shu pointed out that harm is also not only caused by products, but also by actions. And then also there's lots of harms that are not covered by the Product Liability Directive. We asked then the question, who should be liable? And Philipp pointed out the value chain. Then Miriam, I think it was, pointed out the nature of AI systems and the level of autonomy that have to be taken into account. Is it that the AI system is fully autonomous, or is it that there is a collaboration? And then, of course, the question is, how should it be regulated? There's strict liability, there is fault liability. Should it be a sector-specific approach? Should it be a general approach? Should it be a risk-based approach? Also, how to attribute actions, how to attribute knowledge, and also how to define the duty of care. And then I think also one of the most important questions here in the European context is, do we need an EU level harmonization here, or do we leave this to the member states? And here I think we had really opposing views. Those who are in favor of more harmonization because they claim that otherwise there is a fragmentation of legal systems. Others that think, well, we should be more cautious. We have already the AI Act, we have the Product Liability Directive, we have tort law, and we also know, of course, how difficult it is to harmonize tort law to a greater extent. Not even at the academic level, actually, it was possible here to reach a compromise. I just want to remind you that we have the principles of European tort law, but then we have also the draft common frame of reference that deviates from these principles. So all in all, I think this was a very fruitful webinar. I also would like to express my thanks to the speakers, Beatrice Schütte, Philipp Hacker, Miriam Buiten, Shu Li, Mindy Duffourc, and last but not least, also you, Jan. We co-organized this event. So this is not only a Rails webinar, this is also a CTIP webinar. And of course, we hope also to welcome you soon. And I would like to point out that our next Rails webinar takes place already next week on Thursday, on 26th of March, between 5 p.m. and 6:30 p.m. And in this webinar, we will discuss the European Council's AI Convention. Everybody talks about the AI Act, but actually we have the first internationally binding legal instrument, the AI Framework Convention, and we will get some insights from those who actively have contributed to develop this convention. So thanks again and have a good afternoon.
Bye, everyone. Thank you.
Thanks so
Thank
much,
you.
everyone.
Thank you, everyone.
Thank you.
Have a nice
Bye-bye.
day. Bye.
Bye.